You see, what I'm doing right now, you guys, is you guys today, you do not have the right to have your case heard by the Supreme Court because that court believes that it's a court of discretion. You guys believe it's a court of discretion because we were all lied to ever since 1925 by the United States Congress. They said, hey, guess what? We're going to make this court a court of discretion. And they made us forget about original jurisdiction of that court. Forget about it, right? Same thing with the when they told us that we have to petition that court to a writ of certiorari, because that's petitioning the court's appellate jurisdiction, not its original jurisdiction. Because what you're doing with a writ of certiorari is you are requesting that court to review a lower court's decision. That is the court's appellate jurisdiction. Guys, what Article 3 says is it says in all cases in which a state shall be party, the Supreme Court shall have original jurisdiction. In all other cases of equity in law, they shall have appellate jurisdiction. So we're very familiar with the Supreme Court's appellate jurisdiction, but we're not familiar with its original jurisdiction because that hasn't been invoked since 1890. It's been forgotten, right? And yet, even though it's been forgotten, doesn't make it valid. They intentionally misled the people. They told the people that the only way you can petition it is by using its appellate jurisdiction, invoking that, and they said it's a court of discretion. Congress cannot amend the Constitution of the United States. They could propose amendments, and once proposed by 2/3 and passed by 2/3 of both House and Senate, then it goes out to the states, and once 3/4 of the states adopt it through suffrage, then it becomes part of the Constitution. That's the only, Congress can't change it. So if Congress came in and said, well, you know what, we're going to make that Supreme Court a court of discretion, that law, the 1925 Judicial Reform Act, can only be valid and constitutional so long as it doesn't breach the obligations of the Constitution. So the court can be a court of discretion, but only if the state is not named a party. If the state is named a party, they don't have discretion because that's an obligation created by the Constitution. So, so here we go, right? We are not asking them to hear anything because that's our servant. Supreme Court works for us. It's not above us. It works for us. And when we go there with the writ of certiorari and we ask the court to please review our lower court's decision, we give that court the opportunity to say, oh, well, if you're going to ask me, I'm going to say no. We're not asking court. We're telling you that you have an obligation that you must fulfill, right? So what I'm doing is I am establishing the obligation so that you all can have the right. Because you don't have the right today because the first step is we got to show that there's an obligation. We're not going to get any action out the edge. You guys can go in, you can file motion after motion to void your judgment or absence of jurisdiction. None of that's going to work until we show that there's an obligation for that court, the top court to hear it. They don't want to admit it, but it's absolutely true. And it's not only upheld by the Constitution, but by the founders' own words, John Jay, Alexander Hamilton, and James Madison. It's upheld by the Judicial Code. I mean, everything is true about the fact that if the state is a party in the cause, that state cannot be presumed to be neutral and biased to act as a judge of the cause. And as a result, the body of men that make up the state cannot be both accuser and judge, or else the judge has a conflict of interest. He works for the plaintiff, the same person that the prosecutor does, and police and everyone else. No man can be judged in his own cause. So when the state comes at you with an allegation, whether it's CPS, whether it's law enforcement, whether it's a prosecutor, if the state comes at you with an allegation, that state cannot be judged in that case because the judge has a constitutional obligation to recuse himself because original jurisdiction is assigned to the United States Supreme Court according with the Constitution of the United States of America. So the Judicial Reform Act, it cannot alter the Constitution of the United States. Only an authentic act of the people can amend the Constitution of the United States, and that has not been done. So we can tiptoe around it if we want, but at the end of the day, Congress, you didn't have authority to be able to make it for everything. You could for anything other than a state, but if a state's named a party, that's an obligation, and you may not alter the obligation because that would be amending the law. So that's why we had to figure out a different way to petition, because we couldn't petition through writ of certiorari. We couldn't ask that court to review a lower court's decision because then we would be invoking appellate jurisdiction, and they can use discretion in appellate jurisdiction, but they can't in original. So that's why we had to come with the different writ. That's why we had to come with the writ of habeas corpus, because that court only allows certain writs. I looked at the writ of substance. I was sold on the writ of substance. I thought that was the one that we were going to do. No, I'm not getting enough sleep, but that doesn't matter, guys. Don't worry about me, okay? I'm out here on the road, and when I'm on the road, it sucks, right? It sucks. But so there's only a couple writs that you can use with the United States Supreme Court under our jurisprudence. One of them is the habeas corpus, and that's written in the Constitution. The Constitution says specifically under Article 1, it says that the privilege of writ of habeas corpus shall not be suspended except for in case of actual rebellion. And now, that means that we have the established privilege of the writ of habeas corpus. It's always there, except for in case of actual rebellion, which I've already mentioned that I'm concerned about. Some of the things that's happening out here on the political front. I'm concerned about us, being being brought together in a little bit of conflict, with the political polarity that might exist with the stuff on the board. I'm afraid that some of the things that they're doing is trying to get us so that we will act in such a way that they'll be able to say that we're now in a state of rebellion, so that they can suspend the habeas corpus, because that's really the only play that they have. And that's why we want to be really, really careful here, because if they try to create conflict, we want to be able to head that off really fast, guys. We want to, because government is doing a lot of stuff right now because they want to get out of this. They don't want this to come forward, guys. What we have here is we have the United States Supreme Court, the highest court in the land, right? The top court, the court that directs all the courts in the country on how to do business, on what to do. Yeah, I'm working on water. I'm trying. The highest court in the land. We have the highest court in the land that in 1833 directed all the courts within the United States of America that they don't have to give the Bill of Rights and things in the Bill of Rights to the people, because that's only a restriction against the federal government and not the state government, as they said. Now, that's not true, you guys. That's not true. Article 6 says that the judges of the several states shall be bound thereby anything in the Constitution or laws of any state contrary notwithstanding. So if the state judges are bound by anything in the Constitution, then obviously the Constitution applies to states. And if the Constitution applies to states, then the Bill of Rights has to apply to states because it's part of the Constitution. That's Article 5, the Special Amending Procedure. It says once ratified, proposed amendments become part of the Constitution in all intents and purposes. That's what it says in Article 5. So once the Bill of Rights was actually it was passed by 2/3 of both House and Senate, and then it went out to states. Once 3/4 of states ratified it through our suffrage, then it became part of the Constitution in all intents and purposes. So the question would be then is, this judge in, say, Washington, or the judge in Virginia, is this judge in Virginia bound by the Constitution? Yeah. But why is he not bound by the Bill of Rights then? Well, because the rights apply to people. His obligations are within the first articles, but his obligations are to preserve those rights that are enumerated within the Bill of Rights. So to say that the people of the United States don't get what the Bill of Rights says, such as the grand jury, is preposterous. Absolutely wrong. But you guys got to understand that the reason why the Marshall Court made that decision in 1833 was because they were trying to pave the way for the First National Bank. They wanted the National Bank to be put in place. They knew it was coming. They knew the states were going to sue if they established it, and they needed to find a way so that the states could not sue. So they said they got an opportunity with Barron versus Baltimore, and they said, Constitution doesn't apply to states, to the Bill of Rights. And in doing that, remember, to bring a case to federal court to sue, you must be directly impacted by the law. So if they were bringing the National Bank online, and they ruled right prior to that the Constitution doesn't apply to states, then what that means is that the states are not impacted by the law. Therefore, they don't have standing in federal court. They can't sue, and thus Marshall paved the way to permit that First National Bank to be put in place.